car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome. You are watching The Attorneys. I'm Art Franklin. On this show, we're taking a deep dive into the crucial aspect of the legal world, which we call Litigation 101. So whether you have been involved in a lawsuit or whether you're thinking about pursuing a lawsuit, this is a show where you will certainly get the information you need so you can understand the litigation process. But working right now for you are attorneys at Hollis, Wright. They're standing by, manning the phones, and we do that at the start of the show, and they'll be manning those phones throughout the show. All you have to do is call 1-844-LAW-TALK. It is a free and confidential call. So glad to have you with us, and so glad to have us with us as well, Clay, is Ed Merrill.
Yeah, absolutely. This is going to be a great show. It's something that we've never really done before. One of the things that we get caught up in sometimes is we overlook the fact that 99.9% of the viewers are not lawyers.
That's right.
And sometimes we get caught up in the weeds talking to our guests who are lawyers. Josh and I are lawyers as well. And we talk sort of in legal abstracts that may not be clearly understood by the viewers. And today...
Or the host.
Or the host, fair enough. But although you're getting a quasi-law education
exactly.
up here. So today we're going to have Litigation 101. We're going to really break it down into simplistic terms to give the viewers really some practical tips if they're thinking about filing a lawsuit, or if they've had a lawsuit filed against them, the do's, the don'ts, and what they can kind of expect through the process. And I'm so grateful to have Ed Merrill on with us tonight. Thanks, Ed, for being here.
Appreciate it. I appreciate you letting me here.
Sure. Tell the viewers a little bit about you and your law practice.
So my name's Edward Merrill, and I've been practicing for just a little under 12 years now. Most of what we do is some sort of civil litigation. Especially contract related. We do a lot of divorce, custody. On occasion, we'll do some criminal cases, things of that nature, but the majority of the stuff we handle is going to be some sort of civil litigation.
So let's talk about a lawsuit. Somebody thinks they've got a lawsuit, they're going to file a lawsuit, or they've had to file a lawsuit against them. What are the ins and outs of filing a lawsuit or defending a lawsuit?
So, it's two very different things. First, you're looking at the plaintiff side of it, somebody who wants to file the suit, versus the defendant side. The answer is a little easier when you're on the defendant side. If you get served with a lawsuit, you definitely want to talk to an attorney, and you want to make sure that you get those responses in a timely manner. However, on the other side of it, if you're the plaintiff, you got to sit down with an attorney and decide, what am I even going to sue this person for? What do I have in front of me? What can I do? What are my chances of success? How much money am I going to make? If I'm not going to make any money, am I going to get some sort of equity or some sort of relief out of it? And that's a long conversation to have with a client, unfortunately.
Yeah, whether they have an attorney or they don't have an attorney, explain what goes into deciding or determining where the lawsuit is filed.
So the first thing you look at is where did the events occur? And so, car wreck cases are some of the most obvious, because the car wreck case is the suit's going to be wherever the car occurred. You get into a lot of the things we do, for example, contracts, not necessarily where the contract occurred, because you might have a contract that was signed in Georgia, but all the events occurred in Alabama. You might have something that happened, they might have signed the contract in Shelby County, but the case may be in Jefferson County because of where the defendant lives. So it really depends on where the parties are, and unfortunately, more often not where the defendant is.
Yeah. Now, it's really a county-based decision on where you're filing your lawsuit, and we've talked in terms of circuit court and district court on the show before. What are the differences between circuit court in Alabama and district court in Alabama?
So pretty significant difference when it comes to the money side of it. District court in Alabama is now, it used to be $10,000 cap, it's now up to $20,000. But that's everything included. Anything that you believe that you're entitled to has to be less than $20,000. If it's over $20,000, even by 1 penny, then it's going to go to circuit court. But one of the other fundamental differences really boils down to the jury side of it. District court cases are exclusively decided by a single judge, whereas circuit court cases can be a judge or a jury. We talk about our constitutional rights and wanting to have a trial by jury of our peers. You don't have that right necessarily in civil court, but if you choose to exercise that right and you want to have a jury, the only place you can do that's in circuit court.
Yeah, and I think it's important for the viewers to understand that if you've got a controversy involving $10,000 or $15,000, you can file your lawsuit in circuit court. You don't have to file it in district court, even though the amount of controversy is below $20,000. But the issue is it's going to take longer to litigate in circuit court, and it's going to be costlier. It's going to be more expensive to litigate in circuit court, and therefore the cost and timing associated with pursuing it in circuit court may very well outweigh the recovery that they could expect to have.
That's absolutely true.
Yeah.
And that's a conversation we have daily with people.
And I also think it's important for the viewers to understand a little bit broader view, which is we're talking state court. State court is divided up into district court and circuit court, but then over here we've also got a federal court system, which is also a system that people can file lawsuits in, but it depends on, there are a lot of factors that go into whether or not you can be in federal court, so we're really kind of zeroing in on the state court process here tonight.
That's correct.
And you know, Ed, we call this Litigation 101, so help me out. Where do I start if I want to file a suit against someone?
All right, so the first thing you do, if you choose not to hire an attorney, I would always recommend you hire an attorney.
Hire an attorney.
But if you choose not to, what you need to do is you need to start with an actual complaint. Some cases there are some forms that you can use, and you can get those from the courthouse. Other cases you just have to draft it yourself. You have to start with a complaint. You have to list who the parties are that you're going to sue. Some basic facts, and Alabama requires you to have at least some general facts about what happened. You have to have some sort of an idea what it is you're asking for. It doesn't necessarily have to say count one is this or count two is that, but you do need to at least explain what you're trying to accomplish, and it has to be related to some sort of law. Then you have to tell the court what it is you want, what you're expecting. You want some sort of money, you want some sort of relief. If that's what you're asking for, that has to be in there. You do have to sign it. That's very, very important. The rules require signature. And then you have to serve it. Serving it means you can ask the county to serve it for you. They can serve it through the sheriff's department. They can serve it through the certified mail. And now we have the ability to serve through commercial process like UPS or FedEx. That's how you get the case started.
Yeah. I think one important aspect to Ed's comments is that you are allowed to represent yourself, but that is very narrowly defined. So for somebody out there that thinks their business was done wrong and they're an incorporated entity or an LLC, they've got some type of business entity out there, a non-lawyer individual cannot represent their own business. They can only represent themselves. Likewise, that individual cannot represent their individual business partners. They could represent themselves, but again, these are things that they have to consider when they're trying to make a decision on whether they're going to hire a lawyer or represent themselves. Those are considerations to make.
Good stuff, good stuff. We are just getting started as we're talking with Ed Merrill, and this is Litigation 101 as you are watching the attorneys. Also want to remind you, go ahead and sign up and share our social media. We're on every platform out there, whether it's Twitter, which is now called X, of course, and Instagram, Facebook, YouTube, also on TikTok as well. Very good content you'll find there, and that's information you can find throughout the week, so when you're not watching us on the weekends. Stay with us. We'll continue the conversation when we come back. You're watching The Attorneys.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
At Hollis Wright, we don't cut corners when helping our clients. Financial resources matter, and we know it. If it's a car accident, a work injury, or a defective product, we have the resources to help. Let Hollis Wright tell your comeback story.
Welcome back. What it means to have your day in court. We're talking Litigation 101 as we are continuing here on The Attorneys. And with us this evening is Ed Merrill.
Yeah, we've actually got a viewer question here that's to some extent kind of humorous, but it says, why can't the judge just issue an order based on the complaint that I filed? I guess what they're asking is why can't the judge just accept my allegations as true and give me what I want?
Yeah, unfortunately, that's a question I hear quite frequently. People are very passionate about their positions. They believe that their case is right, whether they're on the defense side or the other side. And so it's hard for them to grasp that the litigation process is something that takes time. That the judge is supposed to be somebody who's unbiased. And if the judge were to just read your complaint and say, oh, I agree with this person, and grant the order, the other side wouldn't have their opportunity to come to court. And so I think that's a frustrating point for a lot of clients, is they just don't understand why that process takes so long, why the judge can't make a quick decision on it.
Yeah, the old saying, I just want my day in court, right? Well, the other side wants their day in court too, right?
That's right.
So you've got to give both sides an equal opportunity to engage in some level of what we call discovery. Mm-hmm. Okay, you've made these allegations against me, show me all the proof you've got. And then you've got to give the defendant an opportunity to say, no, I disagree with your allegations. Here's all the evidence that I have to support my position. And that can oftentimes take months and months and months to develop. But ultimately, the idea is to arrive at the truth, or to have enough and all of the information on the table so that a judge or jury could render their decision based on the evidence in the case.
That's exactly right.
Yep. Time-wise, I guess it depends on whether you're in district court or circuit court, but what can people expect in terms of the length of time generally to take to get their case resolved in district court and also in circuit court?
So, I mean, circuit court, you're definitely talking about something longer. District court's a lot shorter. They average between 3 and 9 months. And that's true of your evictions, your minor breach of contract cases, your small construction cases, things that small claims cases, for example. But by the time you get to the circuit court, that's where that time span really goes out. You're looking at 2 years, sometimes longer for some of these cases.
Yeah, and as I understand it from my practice, really the primary contributing factor or driver for that additional length of time is depositions.
Yeah.
Not only depositions, but also experts involved. So Art, through the process that we go through in circuit court, you're allowed to take depositions. Depositions meaning you come to our office or we go to another office, everybody gets into a conference room, there's a court reporter there, and hours upon hours of deposition testimony can be generated through the lawyers asking questions of various witnesses. We don't have depositions in district court.
Correct.
You can't take depositions. You can generate documents and exchange records and things of that nature and then go try your case, but there are no depositions. Also in circuit court, there's an opportunity to disclose experts experts, depending upon the complexities of the case. Both sides will have an opportunity to disclose experts to give expert testimony relative to the case.
And when I'm thinking about, the length of time for these cases and everything that goes into that, also wondering just how much will it cost me as I am following the case?
And obviously, when you look at the time difference between the two, that's a significant factor. I mean, if you're looking at a district court case that's going to be 3 to 9 months, the attorney's fees are a lot less. When on the hourly rate side, you're typically looking at something that's between $2,500, maybe $7,500 on the high end. However, you get into that deep discovery, you start hiring experts, you start looking at all these different factors that are going on, the motions, the various different hearings that you're going to have in circuit court, and then you get to the trial and you start picking jurors and you start going through that process. That's going to range anywhere from $5,000 to $100,000 typically, and it can be a lot more than that.
Yeah, you could have situations where your expenses litigating a case in circuit court could be $100,000 plus just in expenses.
That's right.
But that's also why when we talk about the contingency fee arrangement, we talk in terms of a third contingency fee all the way up to 50% contingency fee. So lawyers like myself on the front end, if somebody comes to me about a medical malpractice case or a product liability case, I know immediately that in order to be able to successfully pursue that claim, experts are going to have to be involved. Depositions and experts are high expense aspects of a civil litigation case, and so it could be $50,000, $100,000 in expenses that we would incur potentially in that case. Therefore, the contingency fee has to be higher than that 130 and can get up into that 40 to 50% range. It's a total risk reward type of venture when it comes down to it. So we've talked about the cost associated with it. Why do some attorneys cost more than others?
Well, everybody has seen the disclaimer from the bar that talks about no attorney is different than the other. Ultimately what they're referring to there is our competency level. It's, do we have the same ability to understand the law and the procedures? What makes one attorney more expensive than another boils down to their experience and their skill level. For example, there's attorneys in my office that have 10 or 12 and up to 35 and 40 years experience. We have other attorneys that have only been practicing law since the early part of this year. So there's a big difference between somebody's ability to communicate to a judge, make a good argument to a judge, understand who the judge is. Knowing your judges in your particular counties is huge. Knowing their tendencies, knowing the things that they like, they don't like, makes those arguments better. The more experienced you are, the more likely you're going to have success with that. Yeah, and that's not really an issue that we run into at our law practice because all of our cases are handled on a contingency fee, percentage type recovery basis. But it is a big issue if you are working on an hourly rate. I mean, you'll have some lawyers out there, entry-level lawyers that might be charging $100, $150 an hour, and then you may have some of the very seasoned, most experienced lawyers that have been doing this type of work or whatever type of work is involved for 20, 30 years. You're getting into the $500, $600, $700 an hour range. So there really is wide variation there. But like Ed says, it comes down to experience, qualifications, and the quality of work that you can expect to get from those lawyers.
All right. We're going to take another break.
Yep.
Right here. In fact, this will be our last break, and that means it's your last opportunity to get in contact with the lawyer at Hollis Wright right now during this show because they man the phones throughout the show. That number again, 1-844-LAW TALK for a free and confidential call. Litigation 101. That's our discussion this evening. Stay with us. We'll continue it right on the other side of this break.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon. We don't love doing TV commercials, but we advertise so you know there are, in fact, differences in law firms and attorneys. If you're looking for a firm that is up for your fight and never quits, you found us.
Let Hollis Wright tell your comeback story.
Welcome back. We're so glad that you're staying with us here on The Attorneys. As our topic this evening is Litigation 101. I also want to remind you, there is a QR code on your screen. If you go ahead and scan that QR code, you will reach an attorney at Hollis Wright. We like to make it very easy for you to get that information. Also, follow us, share on social media. Great content that you'll find on all of our social media platforms throughout the week. We want to make sure that you stay on top of us, not just catch us on the weekends, but also make sure you follow us throughout the week. As we are talking with Ed Murrow, and Litigation 101 is a topic that I think we all are learning a lot about.
Absolutely, yeah. We already talked about the process that a plaintiff will go through in initiating a lawsuit, but Ed, I'd like for you to speak a minute about the defense side of it. What should a defendant do if they unfortunately get those papers served on them, that lawsuit is served on them for some event that happened in their past? What should they do at that point?
Well, the first thing they need to do is talk to an attorney. But more importantly, they need to look at those papers and make sure they're following the timing deadlines on there. For example, in a district court case, you're looking at 14 days. So from the time they get served to the time their response is due is 14 days. In circuit court, that does increase to 30 days. But if you miss those deadlines, I mean, the other side could file for default, and then they get what they want simply because you didn't respond. Yeah. One other act that I absolutely think every individual should take if they are served with a lawsuit is they need to look at the allegations, and they need to at least make some threshold decision in their mind whether or not the allegations could be something that is covered by insurance. Correct. Automobile accident. You get served by a lawsuit for an automobile accident, you've got automobile insurance, you need to turn the lawsuit over to the automobile insurance carrier that you have. Homeowners insurance coverage, if you engage in some type of negligent conduct that causes somebody injury that does not involve an automobile, you need to turn that over to your homeowners insurance. Put the burden on the insurance company to decide whether or not that is a covered event or not, right? That's right, and don't forget businesses as well. Businesses as well, yeah. Business gets sued, they want to make sure that they put their errors and omissions insurance on. Because what the viewers need to understand is if they've got insurance in place to cover the particular event, not only is that insurance company obligated to pay for any settlement or judgment against them, they're obligated to pay their attorney's fees. That's right. So you're going to save in that regard. So it's critically important that they turn that over to their insurance company. Yeah. And then talk about what the defense, what a defendant could expect in terms of the information that they could generate or gather to try and defend themselves. So, you know, going back through the discovery process, if you're trying to defend yourself, you want to make sure that you have witnesses that were around when things occurred, whether it was an auto accident or a roof claim. You know, I see a lot of those where you know, folks have their roofer come out and they're able to testify as to what they saw, what they did, what kind of damage was on the roof. If you're talking about a breach of contract, was there any parties involved in that meeting? Was there anybody sitting there discussing it with you? Right. Especially since in Alabama you don't have to have a writing for there to be a contract. So was there someone around who heard the terms of the contract, and that way you can enforce them? Legal fees. This is always a hot button topic with my clients and or with the defendants in cases. Can you tax the other side with your legal fees if you win the case, and if not, why not? Generally speaking, the answer is no, unless there's a statute in Alabama that specifically allows for it, or through the federal statutes. Generally, you can't because of the way our law is set up. Yeah, so that's one of the differences between us and England is the English rule is a loser pay type rule. Right. So if you lose the case, the other side can tax you with their legal fees. In the United States, we have the American rule, which is a little bit different, is each side bears their own fees. And I think the American rule, not because we're in America, but is a much better rule, though, because otherwise it would deter people that don't have money from bringing lawsuits that have merit
and they are not allowed to get compensated or receive the damages that they're entitled to because they're afraid to pursue the claim based on this loser pays type rule.
That's right.
And there's so much to get into with this subject matter, Ed. I'm just wondering, what kind of cases are you seeing? Has there been a greater influx of certain types of cases?
There has, and I don't really have a good explanation of why, but I noticed prior to COVID, for example, I might have seen a half dozen defamation cases. Since COVID, I'm seeing a couple a week where somebody is posting things on social media that offends somebody. Somebody's posting something about your business, doing some sort of Google review. I see a lot of that with the DoorDash folks. Somebody's saying something bad about the DoorDash, and so they're not able to get new business. So it's definitely an area that's increased a lot. I'm still seeing a lot of contract claims when it comes to roofs, a lot of breach of contract when it comes to construction contracts as well.
On these defamation cases, are these people coming to you and paying you on an hourly basis to have them retract or take down what they've put on social media?
They are. Generally what we try to do is, we start with an hourly fee basis simply because the type of recovery you're going to get in a defamation case is generally not money.
It's very difficult.
Yeah, and it's a hard case to prove. But we try to start with a cease and desist. We'll send a letter to whoever posted it and tell them to take it down. If they choose not to do so, then we can initiate a suit. And as part of that suit, we would ask the court to order them to take down the post.
Yeah. One other thing that I wanted to mention in terms of this loser pay subject, because I've had this case in the last couple of years, is you can contract a loser pay provision in a contract. So if you've got a business on business agreement or a business on business type contract, and there is a lawsuit arising from a breach of that contract, the losing party can tax or have the fees taxed against them in that type of situation. Then also you mentioned the federal law as well. So it's got to be a statute or really got to be a contract in order to be able to transfer or tax the other side with those fees and costs.
That's correct.
Statute of limitations. This is very important, but generally describe what the statute of limitations are for various types of cases in Alabama.
Well, there's different types of statute of limitations, but one of them would be a filing statute of limitations. So, for example, torts or wrongs against an individual, for example, your auto wreck type claims, you've got 2 years from the date of the injury. Breach of contract, we talked about those, you've got 6 years from the date of the contract or the date of the breach of the contract. There's other types of statute of limitations you have to be careful with, excuse me, especially against municipalities.
Yeah.
You got 6 months to do certain things against the municipality and let them know of the likelihood of the suit. Medical malpractice, you've got different statute of limitations. And so that's why it's so important to make sure that you talk to an attorney so that you make sure you meet those statute of limitations, because you can lose your rights to file suit if you don't meet those certain guidelines.
Yeah, well, thanks so much, Ed, for being on the show. You've got a wealth of information to share. I know you've got a very diverse legal practice that you have. How would the viewers get in touch with you? What's the best way for them to reach you or get more information about your law practice?
Certainly our website, www.merrill, MERRELL, lawfirm.com. Or you can call us 205-874-9697.
And I know you handle appeals as well, appeals from the district court to the circuit court and the circuit court to the Alabama appellate court. So I know that's a service that's available as well.
We do.
All things litigation. All right. Ed, thank you so much. And thank you once again for joining, I'd say, the best show around, being with us on The Attorneys. Make sure you join us again next week, same place, same time. So long.
Thanks for watching The Attorneys, sponsored by Hollis Wright.